Good morning, afternoon, and evening, depending your time zone. Today, once again, we have come out to have discussion, especially for Kano State, which there are rising legal implications on what just happened today as Lamido Sanusi receives the appointment letter from Governor Abba Yusuf of Kano State. That is the major issues. But before we get into that, let's take a commentary from what had happened earlier. Let's take a listen.
This morning, Aminu Baba Dan Agundi, the Sarki Dawaki Baba of Kano Emirate, has sued the Kano State Government, House of Assembly, the Speaker, Attorney General of Kano State, and a host of others. In a suit filed on Thursday, 24th of May 2024, Justice Liman of Federal High Court sitting in Kano granted an ex parte order stopping Governor Abba Yusuf-led Kano State Government from reinstating Emir Muhammadu Sanusi II. In the suit, parties are hereby ordered to maintain status quo ante until the passage and assent of the bill pending the hearing of the fundamental rights application. The judge adjourned the case to 3rd June 2024 for hearing of the fundamental rights application. It will be recalled that Kano State Governor Abba Yusuf yesterday reinstated Muhammad Sanusi II as Emir of Kano 4 years after he was deposed, saying the decision to return him to the stool is in the best interest of the state and its people. Yusuf, who signed the new Kano Emirate Bill 2024 into law, declared Sanusi's reinstatement as the 16th Emir of Kano and pointed out that the new law would bring unity to the people of Kano as well as foster sustainable socio-economic development. He issued a 48-hour ultimatum to the man who had replaced Sanusi, Aminu Ado Bayero, his brother Nasser Ado Bayero, and 3 other former first-class monarchs to vacate the palaces and hand over all Emirates property to the office of the Commissioner for Local Government Affairs.
From the very moment I signed the bill into law, it means that all appointments made in accordance with that 2019 law are voided, and the balkanized Kano Emirate has been restored to its original free 2019 status, guided by the provisions of the Kano State Chiefs and Emirs Appointment and Deposition Law 1984 and the Kano State Emirate Council Referral Law 2024, with full support of the kingmakers, I have approved the reappointment of Malam Sanusi Lami.
While majority of the Kano people are jubilating, a reasonable minority is out there. They have gone to court, and there are very serious legal issues, implications that are coming out there. And with me in the studio to discuss all this, we have Divine Dawns, who is going to be presenting all of this with me today.
Very warm welcome, and thank you for joining us on this particular live broadcast. We're so glad to have you, and so
yeah, so let's get this in earnest, Divine, the legal issues. In as much as we are not in the law court here, but we have seen that there is this very ex parte motion which has been entertained by a judge that is said to be outside of the country, and not just that he's outside of the country, but who admitted lacking jurisdiction or having jurisdictional issues as per what we saw in that very originating one. Now, the issues you were asking before as you presented your earlier program about this, what are the questions you have? Because I know you have formulated about 5 different questions you want to ask for our audience to see our own perspective on what is going to be transparent going forward in Kano State.
Well, you know, this particular suit has, you know, legal implications, and there are various questions that have been arising from this in particular. And one of these questions is actually that is this lawsuit not an abuse of the process of court, you know, considering the fact that, you know, this matter is a chieftaincy issue, right? And it is not, you know, under the jurisdiction of the Federal High Court to actually preside over matters like this, right? And so the Federal High Court, under any circumstances, what jurisdiction does he have to actually preside over matters of, you know, chieftaincy issues? And so that's one of these issues that has been raised, because it is really important to note that this is not something that should be, talking about in the fact that it has something to do with the Federal High Court.
The first one has to do with the issue of jurisdiction.
Yeah.
Okay, we'll get to that. What's the second one?
Well, the second question really just borders on, if this particular first question is answered in the affirmative, right, does it not amount to professional misconduct for lawyers to have, filed this case in the Federal High Court, considering the fact that the subject matter and the course of action as reported, right? And so that is another question. And the third question is that, is the presiding judge not equally guilty of, unprofessionalism in having granted this application after having raised the issues of jurisdiction without resolving the jurisdictional issues raised? And so the fourth question is that, was and is this matter properly brought under the fundamental rights, which is the Enforcement Procedure Rules of 2009? And the last but not the least question is that, if the report that the order from the Federal High Court was granted in the night of, the 23rd of May 2024 is anything to go by, the question arises that as to whether an injunction can stop or restrain a completed act, considering that as at the time of the Federal High Court making this particular, statement, the said interim restraining order, Governor Abba Yusuf had already signed the bill into law, as well as, reinstated the Emir Sanusi Lamido. Is the restraining order not a sort of, medicine after date?
Yes, I won't start from the last, which is the fifth one, right. But let's even agree for once that this is actually medicine after date. Yeah. And why I state that categorically is that first is that act is already completed. Yes. The law was passed in the House, and after the law was passed in the House, then the governor Abba Yusuf signed it. You understand? Then after signing it, Sanusi came back and is now the Emir of Kano. So this is a completed act, and but let's get to the issues, the legal issues that you have observed here. And your issue one, which has to do with jurisdiction, on whether this lawsuit is not an abuse of the process of court, considering that the subject matter is a chieftaincy dispute over which the Federal High Court does not under any circumstances have jurisdiction. It is respectfully submitted that the suit is most likely an abuse of the court process by the plaintiffs, Divine. Right. In my opinion, the Federal High Court does not seem to have jurisdiction in the matter. There is hardly anyone that would frame the relief to succeed in bringing the suit within the jurisdictional of the Federal High Court of Nigeria. It is purely a chieftaincy dispute, pure and simple, over which the Federal High Court is incompetent to adjudicate. Right. So, Divine, you see, the issues are very, very trite, right. And there are case laws to support all of this. Right. It is a chieftaincy affair, which has to do with the state. Right. The state court has jurisdiction, and there is different rules that says how this court needs to have jurisdiction. Right. So your first issue is simply on the opinion that I have, which I believe is right. Yeah. The Federal High Court sitting in Kano does not have jurisdiction over a chieftaincy matter. Right. Yeah. And that is the way I look at it. Then on the issue too that you raised, on whether it does not amount to professional misconduct for the plaintiff lawyers to have filed this case in the Federal High Court, considering the subject matter and the course of action as reported, well, I will tell you, Divine, that these lawyers who filed this case may be considered to have committed an act of professional misconduct in view of the provisions of Rule 15 of the Rules of Professional Conduct, 2003. What is the business of Federal High Court in a chieftaincy dispute in Kano State? Right. That is the question of jurisdiction. And when you look at it from the order, that is that very order that was given, first of all, it's an ex parte order. Right. What the court would have gone into is probably asking those plaintiffs to come to court so that it will hear their matter as per jurisdiction. Right. So when they hear the jurisdictional issue and they are satisfied, then they can proceed. He can take it the same day.
Right.
But he first needs to hear the matter of jurisdiction, because if he lacks jurisdiction, what competence, what does the court have to actually give order? You can't give an order when you don't have jurisdiction.
Thank you.
And all of that. But in any case, let me look at the issue too that you have. The lawyers know, let's be clear, or ought to know that under the Constitution, the jurisdiction of the Federal High Court is both exclusive, meaning that it doesn't share its jurisdiction with any other court, and is limited. And it's meaning that the Federal High Court is competent to hear only disputes arising from or connected to the matter. That is, the items expressly listed in the section 251 subsection 1 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Chieftaincy disputes are clearly outside of it. Every lawyer ought reasonably to know. Filing the suit at the Federal High Court is a form of disloyalty to the extant laws, which is forbidden by Rule 15, subsection 3A, which provides that a lawyer must not give service to the client which the lawyer knows or ought reasonably to know is capable of causing disloyalty to the law or bringing disrespect to the holder of any public office. So, divine is, lawyers, they collect money, collect brief, and just move ahead and go to court, just to stop an action, collect money. The same thing goes to the judges. They are not outside of this, because I wouldn't see a reason why a judge who is said to be outside of Nigeria will just take in a matter, cited jurisdictional issues to be heard, and then go ahead to give an order. What gives rise to the order?
Right.
But in any case, let's look at the number 3 of your question, so that so let's look at it from the by virtue of Rule 15, subsection 1A and B. A lawyer ought to keep strictly within the law, notwithstanding any contrary instruction by his client, and must use his best endeavors to prevent his client from causing a breach of law. You can see Rule 15, 3B and C for lawyers who are out there who will be listening in. Now, in this very my sound opinion, I will call it a learned opinion, the lawyers who filed the case at the Federal High Court could be caught under the web of Rule 15.1 subsection 2 and 3 of that RPC, and as such may be qualified as candidate of professional legal disciplinary processes pursuant to Rule 74 subsection 1 of 2023, which provides that a lawyer who acts in contravention of the provisions of Chapter 1 of these rules or fails to perform any of the duties imposed by that chapter commits professional misconduct and is liable to punishment as provided in the Legal Practitioners Act. So, in other words, I'm saying the lawyers who actually did this could be punished, but that doesn't happen in Nigeria. You have not seen, because obviously they are going to use a SILK, which is a senior advocate of Nigeria, to go this, because this is a high-profile matter. And these people are not the kind of people that you just punish anyhow. So, in Nigeria, anything goes. But let's look at your question number 4. So, in this very question number 4, or rather, let me deal with the question of 3, is on whether the presiding judge was not equally guilty of unprofessionalism in having granted this application after having raised the issue of jurisdiction, which I've been saying, and without resolving the jurisdictional issues raised. Well, Divine, the issue is this. The judge reportedly made this very order. That is, if the order was really made, let's be clear, because this might be a fake order, may be viewed as a display of unprofessionalism and may also be seen to amount to a breach of the Code of Conduct for Judicial Officers. And I can take you to Rule 1, subsection 1.2 and 1.3 of the Revised Code of Conduct for Judicial Officers of the Federal Republic of Nigeria, which provides that in 1 and 2, a judge shall avoid impropriety and the appearance of impropriety in all the judge's activities, both in his professional and private life. 1.3 states that a judicial officer should respect and comply with the laws of the land and should conduct himself at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Let me hold that. The judge in present case is quoted to have started by observing during the proceedings that, let me quote, in view of the constitutional and jurisdictional issues apparent on the face of the application, parties shall address the court on the same at the hearing of the fundamental rights application, which is fixed on the 3rd of June 2024, end of quote. After this, the judge still reportedly went ahead to grant injunctive orders sought by the applicant, by the plaintiff applicant. Right. You see what I'm saying? Right. So, he has already said that they are going to address the issue on that very day. Having said they are going to address the issue on the day of the hearing, he should wait. He should not grant that order.
Exactly.
What he should do is to wait so that on that very day, he will hear the jurisdictional issues first to ascertain whether he has jurisdiction first. Yeah. It is when he has jurisdiction that he will now go ahead to give an order.
But you know what's particularly interesting about this here? The point I want to actually bring out is the fact that so many times in our politics we get to see, you know, the Nigerian judiciary to be used as some sort of, you know, caricature, because we know that this actually has no legal standing or backing, at least as far as I know, by the constitution and the laws of the land. And the fact that we just have a group of people just pay lawyers and allow the court is now losing its, you know, essence, because the fact that you can pay money and have anybody give any order, whether or not it's within their jurisdiction to give any order, already makes the Nigerian judiciary look very weak, and, you know, it loses the respect that the average Nigerian has for them. So basically, I'm thinking the fact that even this judge is letting this happen, particularly because he knows, because I stand to be corrected, but I don't think that this man is unaware of the dictates of the law. He knows this. And somebody that is in absentia just sat down one day and gave one order without actually thinking of the fact that he has nothing to do with this, or it is not even within his, you know, jurisdiction. So I think before we even talk about the laws and all of that going on, we just have to talk about the fact that Nigerian judiciary has let themselves become some sort of, caricature, because a court order used to be something that is very important and taken very seriously.
It is no longer important. Let's be clear of that. The stress for people, for our viewers, to really understand the points that we are trying to drive home is in that very order, the judge has accepted the fact that there are jurisdictional issues, but went ahead to give an order. Now, you can't give an order when there is a jurisdictional issue, because it is the jurisdiction. You must first have jurisdiction to be able to give the order. But it is our own opinion and our humble view that since the judge has found or has agreed that the application raised constitutional, especially jurisdictional issues, thank God the judge has so much raised the issue of jurisdiction, which is commendable. But the judge ought to have waited to resolve the jurisdictional issues before proceeding to grant such ex parte orders or any order at all in that very suit. With which, let's even look at it this way, with which jurisdiction did the judge grant the orders reportedly sought? Can a court make any order when it has no jurisdiction? Question for our lawyers out there to answer. The law is, as I understand it, that where issues of jurisdiction are raised, the court shall first of all settle them before going into the matter proper. There are different case laws that is available that all lawyers know. So this very Lord, Honorable Justice Liman, who actually gave this order, should have proceeded to resolve the jurisdictional issues before assuming jurisdiction on the matter. With due respect to the judge granting order of interim injunction when your jurisdiction is at issue is actually tantamount to assuming jurisdiction in the case. A court of law can sit over and entertain a case before it, but only when it has jurisdiction over the matter. And there is several case laws and several case laws that actually does that. Let's draw an analogy from how Justice Ian Ekwo of the Federal High Court, Abuja, had handled a lawsuit wherein an applicant sought an interim restraining order in circumstances similar to the present scenario. That is in the case of Madam Aisha Binani, that governorship candidate of the APC in 2023 election in Adamawa State. And the APC had, in a motion ex parte, sued the Independent National Electoral Commission, INEC, and the People's Democratic Party and his candidates, Governor Fintri, as first, second, and third respondents. However, when the motion ex parte came up before the Federal High Court in Abuja on the 8th of April 2023, the presiding judge, Honorable Justice Ian Ekwo, refused to hear the ex parte motion, citing issues of jurisdiction about what had transpired in the court in that case. It was reported all over the news. And the Federal High Court, on that very Tuesday, refused to hear that very ex parte motion filed by an APC candidate in Adamawa governorship election. That is Senator Aisha Mohammed, popularly called as Binani. Justice Ian Ekwo instead ordered APC's candidate, counsel Mohammed Sharif, to address the court on the issues of jurisdiction first. The judge said, though he was ready to hear Sharif, the lawyer must address the court on the issue of jurisdiction before he proceeded. And in quote, I am ready to, but you have to address me on the jurisdiction, the Judge Ekwo said as at that time. I won't forget that. Now, he ordered Sheriff to address him on whether the court had the jurisdiction to hear the matter, and he held that the application would be taken together with the issues of jurisdiction on the next adjournment. He consequently adjourned the matter to, I think, April 26 for hearing of the motion. So those are the issues. There are different case laws that can actually tell you that there are judges who know that you need to first address the issue of jurisdiction. Right. So, and I don't even think that this very order that I've given, that the Kano State has given heed to it, because that order was done late in the night, just like they did announce the election of 2023 to, that is INEC announcing the presidential election at the middle of the night. That is the same thing that happened in this very instance, or what do you think?
Basically, we can see, because at least just today by 10 a.m., they actually gave him his appointment letter, and he did his, mini Dubas ceremony in Kano State there. So obviously they did not pay attention to this, ex parte order restraining the entire movement. But it just shows that there are a lot of things. They are trying to bypass a law. The fact that he did not talk about the jurisdiction or try to sort the issues revolving around that before going ahead to give that order already makes the entire process a joke. And that is why, the Kano State government did not pay any attention to it, and they just
continued. They just went ahead and did what? Okay, let's take the commentary of the reports coming in from Kano State, as well as there are journalists who are very much interested on what is happening in Kano State, as they have sent in some commentary. Let's take a listen to that.
Heavy security presence at various entrances to the Kano State House of Assembly. The presence of the security operatives within the assembly premises as members arrived to the chamber for the day's proceedings. The day's sitting focused on a bill seeking to nullify the creation of Bichi, Rano, Gaya, and Karaye Emirates. The bill, titled the Kano State Emirate Council Amendment No. 2 Law 2024, was sponsored by Lawan Hussein Gurasa, the majority leader and member representing the Dala constituency. The bill, which has already secured first and second reading, eventually secured the third reading, as members unanimously agreed to the abolishment of the 4 new emirates created by the former governor of the state, Abdullahi Ganduje.
The history of this issue is that the Kano State Emirate, as a geographical expression, is a product and a reflection of historical past. It is necessary, sir, to restore, preserve, and protect the Kano Emirate system as it historically existed and was traditionally recognized for the continued peace, order, stability, and the good governance of Kano State. I raise to call the attention of this House and to agree on this so-called proposed bill, a bill for a law to provide for the repeal of Kano State Emirate Council law.
The new bill states that all offices created under the repealed law have been dissolved and district heads appointed or elevated under the previous legislation are to revert to their former positions.
A bill for a law to provide the repeal of Kano State Emirate Council law 2019-1445 AH, dated to December 2019-1441 AH, Kano State Emirate Appointment, Area Appointment and Deprivation Amendment Law 2019-1440 AH, dated 8 May 2019, and the State Emirate Council Amendment Law 2020-1442 AH, dated 14 October 2020, 1442 AH, and Kano State Emirate Council Amendment Law 2023-1444 AH, and for the other matters connected herewith are hereby passed.
Speaker, there are speculations that the dissolution of the 4 emirates was done to pave way for the return of the deposed 14th Emir of Kanu, Muhammadu Sanusi II. Already, the current Emir of Kanu, Aminu Ado Bayero, and his Bichi counterpart, Nasiru Ado Bayero, have traveled out of the state. The governor of the state, Abba Yusuf, is expected to assent to the bill soon. Until then, anxiety continues to hang over the state.
The major issues, just like we see, this thing has already been done at the state level, and it is the old law has been repealed. Yeah. And after being repealed, it also means that the new one that is active now, how does that affect, and how do the court interpret that? Right. The court is not the one that is making law. The law is already been made, exactly. And it's going. But let's even look at the issues of whether that very thing was properly brought. This, like I said earlier, it's a chieftaincy title, and that's one of the reasons I said it should not be brought under the fundamental rights enforcement procedure of 2009. Now, it is obvious that this is a dispute over chieftaincy stool of the Emir of Kano. Now, if we look at in couching the relief to try to create an fundamental rights enforcement where none exists is an unnecessary gimmick to deceive. So the people who position this thing, they just want to deceive people. The Federal High Court still does not have jurisdiction because the application is not an application for fundamental rights enforcement, properly so called. Else, either of the Federal High Court of the State High Court could have jurisdiction, because in all cases of fundamental rights enforcement outside those arising from or bordering on employer-employee, labor, and trade union relation, both the Federal High Court and the State High Court have concurrent jurisdiction. If the suit is filed under the rules of 2009, of course, there's different case laws that said merely bringing an application under FREP, that is the Fundamental Rights Enforcement Procedure Rules of 2009, does not automatically place it under rules. A consideration of the subject matter of the dispute and the course of action is necessary in determining whether or not it is freedom of a FREP application, properly so called. There are different case laws, Tukru versus Government of Gongola State, 1989, different in the Nigerian law, this thing. Now, there is other pending issues of jurisdiction. That's now. It must be noted that by virtue of paragraph 3A and B of the preamble of the FREP rules of 2009, only the following rights are capable of enforcement under FREP rules 2009. A, rights guaranteed under Chapter 4 of 1999 Constitution. B, rights guaranteed under the African Charter on Human and People's Rights, Ratification and Enforcement Act. Then, rights guaranteed under any United Nations Charter on Human Rights. Accordingly, where the rights the applicant seeks to enforce falls outside the rights contained in Chapter 4 of 1999 Constitution as amended, or in the African Charter on Human and People's Rights Ramification and Enforcement Act of 2000, on the Universal Declaration of Human Rights, or in any other United Nations Charter on Human Rights. The law is that the court doesn't have and would not exercise jurisdiction. The matter must be struck out for being incompetent. That is it. However, under such circumstances, if the Federal High Court ultimately determines that or finds that it does not have jurisdiction, but it is the High Court in the state, the High Court of Kano State or another court has jurisdiction and the power, instead of striking out the matter, he may transfer the same to the relevant and the appropriate court. So the issue is, this matter is a chieftaincy matter. Even if the Kano State government gives an appointment, so even if you call the Emir an employee of the Kano State government, it still will fall under another court, which in this case is industrial court. You understand me? So there are different issues, but I think we'll hold it there because there's a whole lot of issues that we know that will arise out of this. So we just have to cut this. Of course, you can go to the comment section. I know our lawyers are out there. If you share these are our determinations here, and the courtesy of Sylvester Demezwe, who actually have a whole lot to bring in about these very particular determinations and issues that will arise out of the court matter coming out from Kano State. So we'll end it here until we bring when they do finally sit on the 3rd of June, when the court finally sits, then we can now take it off from there. So, but for now, let's reserve some of these things so that we can hit back again on what this court do. But if this judge is actually in the United States, I don't know whether there is no judge again sitting in Kano State that should be able to handle this matter, or is the only one that is being paid by the APC to get that very job sorted out for them. And maybe being in the US and the exchange rate issue is happening, maybe he needed dollars actually to be sent, you know, so that he can be able to deal with his stomach infrastructure. But again, these are maybes and maybes. So thank you for now as to other things that concerns the Obidient family. As we know, the cooperative is doing very well across the federation. More than 60 local governments in Nigeria being registered as in their different with their different state government as Obidient Family Cooperative in their respective states, and they are all coming together as one body in unity for them to actually deal with their different businesses, mutual cooperation, and all of this. So wherever you are, please do find out about the cooperatives operating in your area, the Obidient Family Cooperative, or not other cooperatives, but the Obidient Family Cooperative Society in different local government. And if you are unable to find one, please do click on the link that we share on the description of this video so that you can get into the community platform where you will now find different cooperatives of the local government where you belong, so that you go in. And I want to remind well-meaning Nigerians and Obedience Worldwide that, again, on Sunday, we usually have our Obidient Family Cooperative Society meetings by 7 p.m. in the evening. I'll be displaying that by tomorrow so that we know that on Sundays by 7 p.m. We usually share a Zoom invite link in our platform where all obedience is appreciated to join in the deliberation and the report of ongoing registration with obedience. Until tomorrow, when we come your way again, bye for now.